boldip.com.
J.D. Hoovener, and I'm the founding patent attorney here at Bold IP. It's an honor to spend some quality time with you today to share with you how we do IP law a bit differently than the rest. Bold IP is an agile law firm whose mission is to serve the bold and the brave. That means we strive to serve everyone, from solo entrepreneurs and small businesses to Fortune 500 companies. Bold IP focuses on intellectual property law, including patents, trademarks, copyrights, and trade secrets. Our team specializes in aerospace, healthcare, and software. We have industry-leading experience in those technologies, and we love seeing innovation in those fields. So bring it on. I want to introduce Bold IP, Bold Ideas, The Inventor's Guide to Patents. This book is out on Amazon.com and is available at your local bookstore. Author, J.D. Hoovener, yours truly. Our firm connects with small businesses and their individual inventors. We help them make that big decision about whether to move forward with that bold idea. Give us a call or send an email and set up a free consult today. Look forward to hearing from you. Go big, go bold. Today I'm here to talk about one area of innovation that is top of mind lately. It's the holidays, right? Thanksgiving, Christmas, New Year's just coming up. These events usually involve food and such good cooking. And it comes up almost every year. You know, Uncle Joe has got his new recipe for his bean casserole. Or Grandma Suzette has got her famous turkey or ham that she's been just bringing out year after year. And she's got the secret recipe that she just won't tell anybody. The question is, are those recipes patentable? Could someone actually protect those recipes and keep them as their own, excluding anyone else from using that exact same recipe? I'm here to tell you the answer is yes. Food and recipes are patentable, subject matter, at the USPTO. And I'm here to tell you just a few of the main criteria, as you may have heard me talk about before, that each patent, any patent, whether it be a recipe or not, needs to meet. But then how each of those criteria are specifically needed for food. So let's march through. Food, it is patentable, and it's going to be listed under a composition of matter criteria, and it must still meet the three main tenets. It must be new, it must be useful, and it must be non-obvious. So let's go over the first one. It's got to be new, okay? Because food has been around such a long time, there's an immense body of knowledge and all the different publications, whether it be patent applications or just a magazine article that talks about the recipe and the food products that go into it. Being able to show the patent office that you've got something truly new that's never been done before might be quite the challenge. One of the ways you can do that, and we've helped inventors do this, is break it down to the minute level. What do I mean by that? Well, I mean the really minute level, like molecules. Discuss how the chemical composition is actually different from what's used in common foods. This is how you might objectively differentiate yourself and your invention from the foods in the past. What's more difficult than showing how something is new is showing how it's non-obvious, meaning someone that cooks, someone that's a chef and prepares food. Let's say you've got a specific type of soup, a new chili soup that you're preparing. Being able to show that that soup is something that wouldn't be obvious, whatever ingredients and flavorings you have in there is part of your recipe. Saying how that wouldn't be obvious is going to be probably your biggest hurdle to go down. So, this means that you've got to convince the examiner that food would not have been a trivial or routine advance beyond other previously disclosed foods. So this factors are that you have to compare what's out there now. So what's out there in the bean soup recipe world before your invention, or as it is now? What does the layperson know, or what does the chef know about bean soup? Okay, that's the starting point. examiners will say, okay, here's your invention. What's the difference? Hopefully there is a difference, and you describe that when you're arguing how it's new. And then the question is, well, is that difference enough? Is there any teachings, methods to motivation so that someone who does prepare that kind of food, would they be able to apply what's out there in the common knowledge to get them to your recipe? That's the challenge. The third and final piece is not a big deal. It does have utility. Food in itself does serve to provide nourishment for human body. The fact that it's a new and non-obvious variant thereof will meet the test for utility. Along with other factors, if you can get all three of those past the examiner, you've got a patent. So anyway, I hope this was a fun way to discuss food and the holidays and still talk about patent law, one of my favorite subject matter. So without further ado, we'll let you go. It was nice chatting with you, and I hope all of you have a wonderful holiday season. Go big, go bold.
Go big, go bold at boldip.com.